Good evening, dear students. Welcome to the second lecture on Real Security, strangely enough called Real Security 2. This one will be much shorter than the previous one. I wish to only draw your attention to one or two aspects. First off, I want to have you take a very good look at the categories of liens. Oh, and by the way, the word is pronunciated lien, not lean. Lean, you lean on me or you lean on the tree. Lien. Okay, so firstly, you get a lien when there is some sort of origin of debt. Okay, this means that someone has lent something to someone else, and because of that we see that a debt is created. So this is then divided into two categories. First we have contract here on the left, and on the right we have got unjustified enrichment. Please note that these two do not overlap. Okay, let's go back to contract. You will see here that under contract we have got debtor-creditor liens. What this means is that a debtor-creditor lien can only come into operation if there has been agreement between the parties. It should be fairly obvious, but note that the agreement is of course based on contract. So this is what usually happens when you take your car in for a service and you ask the service station to please change the oil and replace the worn out brake pads. They will then do this. By doing this, they will expend some money, use some of their parts, and incur some labor costs. You will then be held accountable for the costs. Okay. Accountable. Fine. I hope you can see where this accountability comes from. It comes from the origin of the debt, which arises because of contract. This origin rising from contract creates a debtor-creditor lien between you and the person performing the service for you or spending some money on your car, and therefore you will be accountable. So what does this mean? This means if you do not pay the main debt, okay, let's call it the main debt. It means if you don't pay for the brake pads and the oil change, which you contracted for, the service station is allowed to deny you access to your vehicle. You won't get your vehicle back. Fine. Until such time as you are able to pay off the main debt. Note, in that circumstance, if you want to make use of the res vindicatio to get your car back, the res vindicatio will in most probably be denied by the courts. Let's now move on to the other part, unjustified enrichment. In terms of unjustified enrichment, there is in many cases no contract. Okay, it means that something happens where someone is spending money on your object or on your property. You did not ask for it to happen. You didn't contract for this, but because of this happening, you would have been unjustified enriched. And remember, for there to be unjustified enrichment, it means that the other party actually needs to lose something. Okay. They need to lose something for you to be enriched. And unsurprisingly, under unjustified enrichment, you find enrichment liens. And these can be divided into two categories. First, we have salvage liens. This relates to things, expenses that are spent and things done which are necessary. And on the second place, we've got improvement liens. These are things that happen because they are useful. And you will now remember that there is a third category, but for the third category we do not get a lien. The third category is, of course, luxurious expenses. Unfortunately for the person spending money on this, luxurious expenses do not create an enrichment lien. Now go and read through all the different examples. Make sure that you have a very good understanding on how the interplay works between the different actors in this. Person spending the money, this person's asking for the improvements, and the person actually at the end of the day who is the owner, who often did not ask for things to be done, but who might be required to pay for the improvements. Finally, we get to the case of Singh versus Santam Insurance. This case is one of my pet cases where I really like talking about it. Unfortunately, I will not be talking about all the details today because you have to read it yourself. And I would like for you to read this case in its totality. In other words, find the case on the internet, use Tutor or Lexis, download the case and read it from the beginning to the end. Because if you do not do this, if you just rely on the textbook or the additional case guide, then you will not see the big picture. Fine, you have read through the case. Now I want to ask you a couple of other questions similar to the ones asked in Real Security 1. Who are the parties? Are you sure that you know who the parties are? And how do they relate to each other? Who was insured by whom? Who caused the accident and who's responsible for it? Make very sure that you know the answers to these questions. They are not obvious, and in all probability you would have had the wrong impression if you read the case only briefly or only read it once. Go back, have a look at the introduction and try and find out who the actors are. Very well, we've discussed the parties. Now I want you to think about who had a lien. Of course, this case also goes about real security rights, but specifically the question regarding a lien. Did the lien fall away? And when did it fall away? Ask yourself what happens when a lien falls away. Can it automatically spring into life again? What was the conclusion of the court? What did the court have to say about this very specific set of circumstances? Make very sure that you understand that once again this case deals with some exceptions to the rule. Make sure that you understand what these are. Thank you. Till next time.